Welcome all. My dear friends, let us continue our journey in the world of patents. Okay, so here you can see the key term here written is opposition. Okay, and in the picture we can see there are very two beautiful roses, but yeah, both are not similar. Okay, so as they are having different properties, different features, opposition can happen. Okay, so here the key term I have taken is opposition. Okay, and a great man has said it is opposition which foretells success. Where there is no opposition, there is no success either. That means opposition is not bad. Opposition is also needed sometimes. Some many more examples can be given that for a democracy, opposition is needed. So many things are there we can say. So literally we can cite various examples on opposition. Okay, so here just take a look what happens. That means this flower is opposing this flower. Okay, just a symbolic picture, nothing else. Why I am telling all these things? Because the form number we are going to discuss today is form number 14. Okay, so till now we have discussed about all the relevant sections and rules based on up to form number 13. That means up to form number 13 we have completed all the relevant rules and sections. Okay, so today is the turn for form number 14, and form number 14 talks about opposition. Okay, that's why I have told you so many things. Okay, so this is the literary world, this is the nature we can say, but we will go to our legal world and see and observe and watch how the term opposition has a very significant value there. Okay, so let us continue. Go to form number 14. The title is Notice of Opposition to Amendment or Restoration or Surrender of Patent or Grant of Compulsory License or Revision of Terms thereof or to a correction of clerical errors. So all these things are included here in form 14. It is a lengthy one. The title is a lengthy one. Okay, and the related sections and rules are also we can say the number is more. Sections related are, the related sections are 57, 61, 63, 78 and 87, and the related rules are 81, 85, 87, 98, 101 and 124. Fine. So here let us briefly describe the related sections. Section 57 says amendment of application and specification or any document related thereto before the controller. Section 61 is procedure for disposal of applications for restoration of lapsed patents. Section 63 is surrender of patents, and the title of section 78 is power of controller to correct clerical errors, etc. Section 87, procedure for dealing with applications under section 84 and 85. Okay, and the related rules we will discuss briefly. Rule 81 says amendment of application specification or any document relating thereto. Rule 85 says opposition to restoration under section 61. Rule 87 is surrender of patents. Rule 98 is notice of opposition under section 87 subsection 2. Rule 101 is procedure to be followed in case of application under section 88 subsection 4. Rule 124 is manner and time of opposition to the making of corrections. So you can see as a whole here there are a number of keywords. One keyword is amendment, one is restoration, one is surrender, grant of compulsory license, revision of terms, correction of clerical errors. So many terms are there, and here you can relate these terms here. Section 57 amendment of application, rule 81 amendment of application. Okay, and here section 63 is surrender of patents, and here rule 87 is surrender of patents. Fine. So similarly you can relate all this, particularly the subsections of the sections and the subrules of the rules, with this form number 14. So let us proceed to form number. After refreshing our memory from the old slide about form number 14 and its relevant sections and rules, it automatically comes to our mind that if form number 14 talks about opposition, then also that means earlier we have also read about some more forms which were talking about the term opposition. Yes, it automatically comes. So that's why I have prepared a table here for comparison. Okay, so let us see. Form number 7. The title is Notice of Opposition. Form number 7A. The title is Representation for Opposition to Grant of Patent. And form number 14 says Notice of Opposition to Amendment or Restoration or Surrender of Patent or Grant of Compulsory License or Revision of Terms thereof or to a correction of clerical errors. Okay. So when you compare these three forms, I think it will be crystal clear for you to differentiate between the three, and you will not be confused anymore. Okay friends, that's why I have tried to compare all the three forms here for a clear understanding. Fine. Now section 78. And this comes from chapter 15, that is power of controller generally. Okay, and here we can say that section 78 has the title power of controller to correct clerical errors, etc. Okay, so let us proceed for the detailed explanation. Fine. Subsection 78 and the keywords. Okay. Section 78 has 5 subsections. Okay. So I have picked up the key phrases or key terms from the respective subsections. Fine. So let us take a look. For subsection 1, the key phrase is correct any clerical error. For subsection 2, this is a request in writing. For subsection 3, it is give notice of the proposal to the patentee. For subsection 4, the key term is or the key phrase is the correction would materially alter the meaning. Okay. And at the last, for subsection 5, the key phrase is an opportunity to be heard. Okay. So again I am telling you friends that I have picked up my words. You can choose your own. Fine. And try to remember these keywords so that you can recall the subsections, and subsequently you can recall the section 78 as well. Fine. Okay. So let us proceed. Section 1. This says, without prejudice to the provisions contained in sections 57 and 59 as regards amendment of applications for patents or complete specifications or other documents related thereto, and subject to the provisions of section 44, the controller may, in accordance with the provisions of this section, correct any clerical error in any patent or in any specification or other document filed in pursuance of such application, or in any application for a patent, or any clerical error in any matter which is entered in the register. Okay. So here the key phrase is correct any clerical error. Okay. So the related sections here are just I am taking the titles of the related sections. These are section 44 is amendment of patent granted to deceased applicant. Section 57 is about amendment of application and specification or any document relating thereto before controller. And section 59 is supplementary provisions as to amendment of application or specification. Fine. Also, please refer rules starting from 58 and ending at 63, and also rules starting from 122 and ending at 125. All these are relevant rules. Fine. And also you can see a single star mark here. Just a minute. So here you can see a single star mark, and this indicates the words inside the square bracket is inserted by Act 38 of 2002, Section 37, with effective from 20th May 2003. So just remember these things. Now we will try to simplify the subsection. Fine. So we can say that without prejudice to the provisions of section 57, 59 and 44, the controller may correct any clerical error in any patent or specification or other document filed for a patent, or any clerical error in any matter entered in the register. This is the simple meaning of this subsection. Okay. So you can just I am just reading it again, the subsection. Just try to observe the key points here. Fine. See, let us see. Without prejudice to the provisions contained in sections 57 and 59 as regards amendment of applications, because we know that sections 57 and 59 are regarding the amendment of application. Fine. For patents or complete specification or other documents related thereto, and subject to the provisions of section 44, because section 44 is also dealing with the amendment of patent that are granted to the dead applicants. Fine. Dead or deceased applicants. Okay, up to this is fine. The controller may, in accordance with the provisions of this section means section 78. The controller may correct any clerical error in any patent or in specification or in any other document filed in pursuance of such application, or in any application for a patent, or any clerical error in any matter that are entered in the register. That's all, friends. I hope now it is pretty clear. Fine. So let us proceed for the next subsection. Subsection 2 says a correction may be made in pursuance of this section either upon a request in writing made by any person interested and accompanied by the prescribed fee, or without such a request. Okay, that means a correction is made as per this section, that means section 78, either by a writing request made by any person interested, and see the operator, and we can say and accompanied by the prescribed fee. That means a request in writing along with the prescribed fee, or this is a request in writing with the prescribed fee is the either condition, and there is a or condition as well, that is without such a request. Fine. So okay, let us proceed for the next subsection. Subsection 3. Where the controller proposes to make any such correction as aforesaid, otherwise than in pursuance of a request made under this section, he shall give notice of the proposal to the patentee or the applicant for the patent, as the case may be, and to any other person who appears to him to be concerned, and shall give them an opportunity to be heard before making the correction. Fine. So the key phrase here is give notice of the proposal to the patentee. Fine. So we can say here the controller proposes to make any such correction as aforesaid. That means that just we have discussed. Otherwise then, in pursuance of a request made under this section as per section 78, he shall give notice of the proposal to the patentee. That means the controller shall give the notice of proposal to the patentee or the applicant for the patent, as the case may be. That means as per the situation, and to any other person who appears him to be concerned, any other concerned person as well, and shall give them an opportunity to be heard before making the correction. That means before the correction is made, these people Okay, these people means any other person. Okay, the applicant for the patent or the patentee, they all will get an opportunity to be heard. Okay, so in we can simply we can say that the controller shall notify the applicant of his proposal for correction of clerical errors. Fine. And before making such correction, he shall provide the applicant or patentee, okay, or any other person who is the concerned one, an opportunity to be heard. This is the simple meaning of this subsection. Fine. Okay. Section 4 says, where a request is made under this section for the correction of any error in a patent or application for a patent or any document filed in pursuance of such an application, and it appears to the controller that the correction would materially alter the meaning or scope of the document to which the request relates and ought not to be made without notice to persons affected thereby, he shall require notice of the nature of the proposed correction to be published in the prescribed manner. Fine. And here the key phrase is the correction would materially alter the meaning. Fine. So we can say here you can see the just a second friends, you can see the star mark here, single star mark, which indicates the word inside the square bracket is substituted by Act 15 of 2005, section 51, section 51 clause A for advertised. Okay, and this is effective from 1st January 2005. So earlier it was advertised, now it is published as per the 2005 Amendment Act. Fine. So the relevant form is Form 14, which is notice of opposition to amendment or restoration to surrender of patent or grant of compulsory license or revision of terms thereof or to a correction of clerical errors, etc. etc. Okay, so say in simple way or in a very simplified way, I can say that when the applicant makes the request for correction of clerical error and it appears to the controller that such a correction would materially alter the scope or meaning of the invention, he shall publish the nature of proposed corrections. Okay, he shall publish the nature of proposed corrections. That's all actually. Okay. So also we can read it again. Just take a look. Where a request is made under this section for the correction of any error in a patent or application, that means there may be an error in a patent or in a patent application or any related document. Okay, and it appears to the controller, that means the controller feels that the correction would materially alter the meaning. That means if the controller thinks that if I correct, the meaning may be changed or the scope of documents may be changed, okay, to which the request relates. Okay, the scope or the meaning to which the request relates, we can say that the meaning or the scope may be changed. Okay, so this should not be done, right? So for that reason, this should not be made without notice to persons affected. That means by this correction, those persons will be affected, they should be notified first. Fine. So then in this situation, the controller shall require notice of the nature of proposed correction to be, he shall require notice of the nature of proposed correction to be published in the prescribed manner. Okay, that means in a prescribed manner, he shall require the notice of the nature of proposed correction. Got it now? Or any problem? No, it's okay. Okay. I'm just reading it again for telling you something. Just take a look. Where a request is made under this section for the correction of any error in a patent or application for a patent or any document filed in pursuance of such an application, and it appears to the controller that the correction would materially alter the meaning or scope of the document to which the request relates and ought not to be made without notice to persons affected thereby, he shall require. Okay, he shall require, that means the controller shall require the notice of the nature of the proposed correction to be published. That means actually what happens, a notice is published. Okay, a notice is published mentioning the nature of proposed correction in the prescribed manner, so that the affected persons, or we can say the would be affected persons, will be notified in an earlier time, and they will get some time to, that means if the nature of proposed correction is not right, okay, as per their or it is not as per their convenience, they can uh, approach the controller. Fine. Okay, now I hope it is crystal clear. Fine. Okay, subsection 5. Okay, and the last subsection of section 78. This says, within the prescribed time after any such publication as of aforesaid, any person interested may give notice to the controller of opposition to the request, and where such notice of opposition is given, the controller shall give notice thereof to the person by whom the request was made, and shall give to him and to the opponent an opportunity to be heard before he decides the case. Okay, the related form is Form 14, that is notice of opposition to amendment or restoration or surrender of patent or grant of compulsory license or revision of terms thereof or to a correction of clerical errors. And the single star mark here which indicates the words inside the square bracket are substituted by Act 15 of 2005 section 51 clause B for such advertisement effective from 1st January 2005. So earlier this was such advertisement, and now this is such publication, and this is as per 2005 Amendment Act. Fine. So we can say that any person interested may give a notice of opposition to the controller within 2 months from the date of publication. Okay. Okay. Another thing I would like to tell you that, just a minute. Yeah. Let me read it again actually. Within the prescribed time. That means you have to find out the prescribed time. Within the prescribed time after any such publication. That means publication is done as aforesaid. That means just now we have discussed. Fine. Any person interested may give notice to the controller. Now, any person interested gives a notice to the controller. For what? For opposition to the request. Okay. That means read like this. May give notice, then read, of opposition to the request to the controller. If you read like this, you can get the essence actually. May give notice. Notice of what? Notice of opposition to the request to the controller. Fine. And where such notice of opposition is given, the controller shall give notice thereof to the person by whom the request was made, and shall give him and to the opponent. That means both are getting an opportunity to be heard before the final decision. Fine, before the decision. Okay, and we can say, yeah, it's fine. So in this way, friends, all the subsections of section 78 are completed. So please go through them. Okay. Now as a summary, we can discuss, or we can briefly discuss section 78 like this. Okay, just take a look. Section 78 subsection 1 empowers the controller to correct clerical errors, etc. Okay, but it does not empower the controller. It does not empower the controller to make an amendment suo moto. Fine, got it now? That means the controller has the power to correct clerical errors, but suo moto he cannot make this. Fine. And the related case law here is Press Metal Corporation Limited versus Nosir Sorabji Pochkanawala, AIR 1983, Bombay 144. So please refer this case law from any search engine. But yeah, after all these section rules and forms are completed, I would definitely focus on the case laws, and that too in separate video lectures. Fine. Okay. So till now, just you can remember this case law and you can search in the any search engine. Fine. Okay. Another case law for section 78 as a whole. Fine. Another case law is irritate incorporation, okay, versus controller of patents. That also we can, when you go through this case law, you can particularly see in which subsection or for which subsection of section 78 this is related to. That all these things we will discuss when I will prepare a separate video for a specific case law. Fine. Okay. And here I would also like to discuss about a particular rule which is in a, we can say, closely related to section 78, and this, the title of rule 122 is correction of clerical errors. Okay. And rule 122 is, we can say, a request for the correction of a clerical error in any document referred to in section 78 shall be accompanied by a copy of the document highlighting the corrections clearly along with the fees payable therefore as specified in the first schedule. As per the first schedule, we can say, and you can refer to the first schedule. Fine. So this way, friends, all the subsections along with a little discussion, we can say, a kind of brief summary of section 78 are completed. So please go through all the subsection, please go through the summary, please go through the Barrett, and yeah, keep learning and keep enjoying. Fine. And whenever you are getting stuck anywhere, please ask the questions in the comment box. Okay, friends? Okay. The reference is Patents Act 1970 as amended by Amendment Act 2005 and the Patents Rules 2003 as amended by Amendment Rules 2021. Okay, friends, thank you all for watching my video and listening to me. Okay, so please like, share and subscribe the channel, and please put down your comments and queries in the comment box. Thank you. God bless you. Stay safe, stay blessed. Jai Hind.